right, everyone, we are back. We're going to go over Chapter 20, Professional Practices. Make sure you have your cameras on. Come on, children, cameras on. Half of you have cameras on, half of you don't. Arlene, camera. Joelle, camera. Daniela, Ed. Cameras, please. All right, now that you had the break, do you guys have any questions regarding previous chapters you want to address now? We're good? All right, cool. So anybody watching on YouTube, you can also participate. As you know, please leave questions or submit questions in the live YouTube chat, okay? All right, so we're going to talk about professional practices. This is a chapter that's, this chapter has 11 questions in the New Jersey state exam, for instance. It's heavily tested. And this chapter, just like agency, and we talked about that in chapter 11, just like agency in the nationwide exam, right? So the national exam is heavily tested, right? So very important you guys pay attention to this. We're going to talk about fair housing laws, property disclosures, and other professional practices, all right? Fair housing laws, that's the first thing. If we see fair housing laws, means we're talking about discrimination. These are discrimination laws and how discrimination is prohibited. Okay? That's what we're going to talk about. Ready? All right, so there's a lot of ground to cover here, so I need you guys to really, really pay attention on this. Because you could lose your license because of discrimination. And this is not just in New Jersey, New York, or anything like that. It's everywhere. These are federal laws. They're not state laws. These are federal laws. So the federal and state governments have enacted laws prohibiting discrimination in the national housing market. The aim of these fair housing laws or equal opportunity housing laws is to give all people in the country the opportunity to live wherever they wish, provided that they can afford to do so, of course, right? So they qualify to be there, without impediments of discrimination, purchase, sale, rental, or financing of a property. State fair housing laws, while the states have enacted fair housing laws that generally reflect the provisions of the national law, each state might have slight modifications. So they cannot go against federal, but they can enforce more than what the basic federal law says, okay? So we have fair housing and local zoning. Fair Housing Act prohibits a broad range of practices that discriminate against individuals on the basis of race, color, religion, sex, national origin, familial status, and disability. The Act does not amp local zoning laws. However, the Act applies to municipalities and other local government entities and prohibits them from making zoning or land use decisions or implementing land use policies that exclude or otherwise discriminate against protected persons, including individuals with disabilities. All right? So, this all started with the Civil Rights Act of 1866. I want you guys to pay attention to a couple of things here. In this chapter, in certain areas of this chapter, I only have the year highlighted. Why? because there's no, this should be easy to remember, there's no other 1866 in the book. So every time you see Civil Rights Act of 1866, you have to remember it has to do with race and color. So 1,866 years it took for people to realize that race and color should not matter. 1,860. We're not even counting before AD. We're talking about in general, like from 1,866 years to see we're all the same, right? And people kind of forget along the way, apparently. Right? It's very clear people forget along the way. Right? And I'm very passionate about this chapter, so I apologize ahead of time if I might say something that might offend some of you, right? If you guys intend to discriminate, by the way, this is not the right class. And by the way, there's no refunds for discriminators. So if you want to quit, you can quit now. No money back, that's all. But race and color, 1866. The original Fair Housing Statute of Civil Rights Act of 1866 prohibits discrimination based on race and color. And the provision relates to selling, renting, inheriting, and conveying real estate. I will explain this better later on. Okay. The next one you need to remember is the Civil Rights Act of 1968. If you guys notice, there's a big gap over here. It took an additional 102 years to figure out, wait, more people should be protected of discrimination. 102 years. You guys realize that? That's 52 years ago. It's not that long ago. It sounds like a lot for a few of us, right? For most of us, it sounds like a lot. But again, considering that it took 1,968 years, 50 years is nothing. So all the laws from here on are very, very recent. The Civil Rights Act of 1968. In terms of real estate, they implemented an amendment to the Civil Rights Act of 1866. This is an amendment, so an addition to it. It's called Title 8, Fair Housing Act. And what they said clearly in this act is that discrimination is prohibited if it's based on race, color, religion, or national origin. They added religion and national origin. It doesn't matter where you came from. We cannot discriminate because you're from a different country. Doesn't matter what religion or creed you have. I don't care. You qualify? Come on, buy the house. You understand? Or rent. So, pretty much as of 1968, race, color, religion, and national origin are effectively protected classes when it comes to fair housing, when it comes to buy or renting. You guys got it? Got to remember this stuff. The Fair Housing Act specifically prohibits such activities in residential brokerage and financing as the following, okay? But I want you to notice something. This is a federal act, okay? So this is a federal act. And the federal act applies to residential, does not apply to commercial, industrial, anything. So when we get to the state portion, each state has more laws. So they enforce a little bit more here or a little bit more there. But federal only talks about residential. That means according to federal law, if I'm helping you buy or sell commercial, I can discriminate, right? So ethically, we shouldn't, obviously. But the law itself does not prohibit us from discriminating commercial, industrial, or anything like that. But for residential, it is very specific that it prohibits any of these activities, like misrepresentation, right? Like an agent may not conceal available properties, represent that they're not for sale or rent, or change the sale terms for the purpose of discriminating. We could not even incentivize something like that, right? And we're going to talk about that in a little bit as well, which is, for instance, blockbusting or steering, right? A lot of agents take a position of, hey, things are changing. This group of people is moving in or moving out of the area, and this is how it affects your property, right? If it's based on people and their race, color, religion, or national origin, for instance, if it's based or any other protected class, then that is prohibited. If it's based on income classes, if it's based on creditworthiness of certain groups, right, based on what we know, if it's based on income or credit, you can always accept or reject somebody. That's not a problem. We're going to go over that. But again, if it's based on race, color, religion, national origin, we're going to talk about sex as well, so gender and familial status or disabilities. We cannot do any type of misrepresentation. Oh, you're not the same as me, so you either pay more or pay less. Right? We cannot do that. We cannot provide unequal services. We cannot do any type of advertisement that's specifically prohibiting certain groups of people. And we're going to go over this as well, where, for instance, I cannot say great house for Christians, for instance. I cannot say great neighborhood for Muslims. Right? That's wrong as well. Right? It's a great white neighborhood. No, we cannot do anything like that, because that's attracting only a particular group of people or targeting a particular group of people and excluding everybody else. That is 100% illegal. Think about this. There's only one color, only one religion that you guys need to practice when you're in real estate. Okay? The religion is real estate. The color is green. You guys understand? So this is my serious face, by the way. So make sure you guys, sorry. Make sure you guys understand that, because you will lose your license if you intend to discriminate. If they are qualified, equally qualified, right, then you have to show the houses, right? Very important. If they're equally qualified, then they're entitled to buy the house, no matter what your client says. This is also very important. We're going to talk about how the seller cannot discriminate either if they're being represented by an agent. You got it? Federal law does exempt, we're going to talk about that in a bit, also exempts sellers from discriminating. So they can discriminate. But if they're represented by one of you, agents, they cannot discriminate anymore. All right? Steering. Steering, if you guys know, if you guys have a car, you know that thing that when you sit in the driver's seat, there's a round thing in front of you, usually where we put our hands, right? That's called a steering wheel. Why is it called a steering wheel? Because it helps us steer the car either to or away from a particular area. To the left, to the right, but either to or away from a particular area. Steering, when it comes to real estate, is us leading a client to or away, so towards or away from particular homes and neighborhoods. So it's pretty much me saying, Joel, if you don't mind me asking, what's your background? Where are you from? Write it down, if you don't mind. I'm going to use you for a second. And guys, don't get offended because I picked Joel, okay? It's not discrimination against anybody, all right? I was about to say I needed a faster typer. So you're Dominican. Great. So you were born there or you were born in the United States? You're born in the Dominican Republic? Okay, great. So I'm going to look at you and you say Bruno, I want to buy a two-family. Right? I want to buy a two-family. I'm going to say, well, you're a Dominican. You want a three-family? Okay, no problem. Fine. I'm sorry. I should have asked. Right? So you want to buy a three-family. I'm going to look at you and you tell me, I want to buy a three-family in, let's say, Clark. Right? I always go with Clark because you don't find many Dominicans there. Let's put it like that. Stop laughing, guys. It's not. This is serious. It's not a laughing thing at all. So Joel says, I want to buy a three-family, but I would like to be in Clark, right? Well, the good thing is that there's not many three-families in Clark, so I can get away with that one. But I cannot say, Joel, I don't think Clark is the neighborhood for you. right? The moment I started assuming or presuming certain things, like based on race, based on religion, based on national origin, stuff like that, automatically, automatically that's discrimination. What some agents do, right? What some agents do, like in a very subliminal way, is say, hey, you were approved up to X amount of dollars. There's no price, no houses on the market right now in this area for X amount of dollars. But if you come to North Newark, right, a lot of Dominicans there. I used to live in North Newark, so I know a lot of Dominicans there. So if you come to North Newark, there's great houses there for the price range that you're approved for. Would you like me to show them to you? See, I didn't say it was specific because you're Dominican. I used the price range and the type of house you want, and I was very subtle, right? Giving you the message, this is not where you belong here, right? That's the same thing as telling you go back to your country. Isn't that the same thing? Like, don't do this, guys. You cannot discriminate. You cannot steer. You cannot, really, Tina? You cannot steer people to or away from areas based on your perception of where they should live or where they like to live. Okay? If Joel wanted to buy something in Clark, I would tell him, look, Clark is not an area that has too many 3 families. We might find a 2-family there if that's what you wish. I will search for you. You understand? But I cannot find every excuse in the book to steer him away from it. You guys understand? That is illegal. The same thing as I'm Portuguese and you tell me, hey, your place is in the Ironbound in Newark, right? Because that's where most Portuguese or the biggest Portuguese group is here in New Jersey, right? So you cannot say that. Do you understand? Nadia says, what about if he doesn't want to be in Little DR? Well, exactly. I'm Portuguese. I don't live in Newark. I lived in Newark, but I don't live in Newark. Who says I want to mingle with them? You saw how I treated Tina before. Like, I don't want to mingle with Portuguese. You kidding me? I got away from Newark. No, it's a joke, but it's the God honest truth. Like, people want to live wherever they want to live. It doesn't have to be because, oh, you're Portuguese, you need to be next to Portuguese. You're French, you need to be next to French. You're Mexican, so you need to be next to Mexican. Come on. No, where do you want to live? You want me to find you a house in Alpine, New Jersey, where everything is like $3 million and most likely there's no Dominicans? Most likely, right? Because that's a select group that goes to that area. I will find you a house because that's what you want. And if you want to put an offer in a house there, Joel, that's what I'll do. You guys understand what I'm trying to say? You got to go based on what your client wants, not what your perception of that neighborhood is. All right? And giving suggestive hints of you're the wrong type of color for that neighborhood, suggestive hints, right? That's also discriminatory. All right? Happens a lot. Okay? Don't do that. He wants to live in the middle of all white people. If he wants to live in the middle of all black people or in the middle of all yellow people, whatever you want. Client demands, we do what the client wants. As long as they're financially able and capable of purchasing the property, it really does not matter. All right? And then he deals with whatever the neighborhood's going to bring him. You understand, guys? It's not our part to judge where he should be or not be or what he's going to deal with or not. I'm sure he would understand what he's getting himself into. Does that make sense? All right? Those are challenges that come, unfortunately, still in these modern times. Somebody had to say, I know Dominican and Alpine. Can you do me a favor and turn on your camera, at least if you're going to talk to us here in Zoom? Can you turn on your camera and be part of it since you're going to say that? I swear she said, okay. Now, what kind of Dominican? There's different kinds of Dominicans, just saying. What kind of Dominican? Anyway, the point was, you guys understand, like, you know a Dominican. A Dominican. Okay. How many are you going to find there, right? And you understood my point. Thank you very much. These people, I swear. Disrupting the evening class when they're not even part of it. All right. So, steering. Taking people either to or away from particular areas. The next one is blockbusting. Can't believe you actually said a DR. I asked what type of Dominican, she goes ADR. Period. There's different type of Portuguese people, I'll let you know right now. There's a transparent Portuguese people, which is not common, right? There's the very dark Portuguese people, which is very common. There's a slightly dark Portuguese people, also very common. Like, I'm a freak of nature when it comes to Portuguese people. You don't find many transparent like I do. And if I were to take the filter that's right here in front of me, you would not see me. I'll be like a ghost. So again, you'd not be able to tell me where I should be or not be, or what kind of group I belong to. And if you see my children, right, my children are amazing. I have a whole palette of colors. I have a very dark brown daughter. I have caramel, right? I swear to God, I have all different kinds, and then I'm still the lightest one. But my children have different ranges of color, right? So a little bit tanner than me, like a lot of it, right? Then caramel, and it keeps on growing all the way to really dark black. And yes, all my children, okay? Anyway, so blockbusting. This is why we can't discriminate. We really don't know where we come from, right? You're laughing. Actually, I was thinking about that the other day. Let me just bring this up real quick. So I was thinking about that the other day, considering everything that's been happening, right? What if everybody in this world, right? You're like 10 sons? No, I have 4. I have 4 kids for now. But anyway, what if everybody took a DNA test to figure out where their roots come from? Would it be possible to guarantee right now, there's no 100% pure breed anymore after millions of years on this earth? Would it be possible? Right. Imagine. Oh, by the way, Joel, there's also the ones that I don't know. So I assume 4 is the kids I have. It's a joke. It's a joke. Dina says, I just did ancestry test, waiting on results. Well, so you guys know what I know. What I know is that I'm Indian, from India, right? A little bit of French, and my dad is from South Africa, Mozambique, which is it was a Portuguese colony, but he's from there. So really wild mix. And from my ancestry, since you did, my ancestry test says that I'm from Morocco. Can you tell? I'm very Northern African, yes. 2020, just drop this BS of, you know, races and colors and whatever. Fabiola says she's cracking up with my jokes. Great. I'm glad I can make somebody laugh. All right. Blockbusting. Blockbusting. This is when you're scaring or inducing owners to sell or rent. All right. So what is blockbusting? You guys remember Blockbuster back in the day, the movie rental place? Raise your hand if you remember this. All right. So the coolest thing about Blockbuster was that they had the latest and greatest. What does this mean? Whatever's on the movie theater, as soon as it came out of the movies, where would you find it? Blockbuster would have it. So what they did, or what they practiced is this scare tactic that says, if you don't get it now, you might not be able to get it. So sometimes a movie would come out and you go run to the store, like the first, I don't know if you guys remember the first Mission Impossible movie. I went to get it right at Blockbuster. And when you got there, if there was one on the shelf, it would be too much, right? Because people would run to get the latest and greatest. So they use the scare tactics. Nowadays, we find that at Black Friday, for instance, right? Black Friday, people kill each other to get there. That means they have the scare, right? They have the scare that if they don't get there on time, they don't get the deal. For real estate, blockbusting is also scaring the seller, right? Is scaring or inducing. So here, let's go scaring the seller to sell because of a change in ethic or social makeup of the neighborhood. And that will cause the values to go down. See, there's already a Dominican in Alpine. Imagine 2 Dominicans. Joel goes there too. What's going to happen to the values of the houses, right? And that's how people see it. It's Joel says it goes up. I'm sure. But your neighbors are not going to see it that way. And the opportunistic realtor is going to start knocking on those doors and say, hey, one move in, there's a second one already. Imagine when all of them start coming in. Sell now before the house values go down. All right? Obviously, I try to make this as fun as possible, make it as a joke, but this is serious. It does happen. It does happen. And usually, we do that to our own kind. I'll give you the most recent example. Ironbound in Newark. I told you that most people that live in the Ironbound, the majority, used to be Portuguese. Before the Portuguese, there was the Italian and the Polish, right? Us Portuguese were able to kick the Italian and Polish out of there. But now we're getting kicked out. The point is, somebody's knocking on our doors and saying, listen, this group of people is moving in, so you should move out now before the house values go down. It's our own kind. The Portuguese are knocking on Portuguese doors and saying, get out. The Italians were knocking on Italian doors and saying, get out. The Polish were knocking on Polish doors and saying, get out. The Portuguese are coming, right? It's unfortunate, but that is the truth. That is illegal. Blockbusting. Did you guys understand it? Good? All right. Redlining is another one. Now, redlining was literally putting a red line around a particular area. Like Newark. And it's the banks and the insurance companies saying, oh, you live in Newark? We cannot lend to you because you live in Newark. So redlining was literally excluding certain areas. That is illegal. If they qualify financially, then they're entitled to get financing wherever they go. You guys understand? So the buyer's qualifications have nothing to do with the area where they buy. Lenders, okay, they would actually draw a red line around the area in the map. Lenders and insurance companies cannot reject or refuse. So every time you see redlining, think about refusing a loan or insurance. Loan or insurance. All right? Every time you see redlining, loan or insurance, refusing. So just to recap real quick. Steering, taking people towards or away from an area. Blockbusting, scaring people into selling. Redlining is refusing. All these based on race, color, religion, or national origin, or any protected class instead of their financial qualifications or desires. Thumbs up? Great. All right. Now, this was all fine and dandy. Like, everybody's protected and we're happy, right? We're happy that we don't have to be scared about applying for something, right? Because we get the housing. They cannot discriminate, correct? See, Title 8, in case you guys don't remember, it's the Fair Housing Act of 1968, the addendum, right, that they created to the Civil Rights Act, right? Also created ridiculous exemptions. So what does this mean? It means that if you really want, you can discriminate. I'll show you how. Ready? That's pretty much what it means. Exemptions means if you really want to discriminate, this is how you can do it. If you privately own a single family home and you're not using a broker, you can discriminate. If your advertisement is not discriminatory, it's okay to discriminate. So as long as you're not like blatantly discriminating. When people show up at your door, you can say, no, not you. That's an exemption in the 1968 law, right? With certain additional conditions. So you guys know the additional conditions here is if you own a single family and you do not own more than 3. So if you want to discriminate, if you have 3 single family homes, do not buy a 4th. Because the moment you buy a 4th, you can no longer discriminate. That's how ridiculous these exemptions are. Okay? And if you're not the most recent occupant, that's another condition. If you are the occupant, no problem. But if it's one of your properties, not the one where you live, you can only discriminate once every 2 years. Like there's a time clock. Okay, discriminate today, wait 2 years. Like, are you kidding me? That's how ridiculous these exemptions are. But it gets better. Rental of an apartment in a 1 to 4 unit building where the owner is also an occupant, provided that advertising is not discriminatory. What we're saying here is that in the 1 to 4 family, owner occupied, you can discriminate. So if you occupy one of the units and you're renting the other 3 or 2 or whatever, right? It's okay for you to discriminate when it's rentals. Okay? If you occupy the building. If it's an investment property that you do not occupy, you don't have this exemption. All right? So owner occupied only. And remember that because for state, it might be different. For federal, it's owner occupied 1 to 4 family. These two, I'm going to put in the same comparison. Facilities owned by private clubs. Facilities owned by private clubs and leased non-commercially to members. Or facilities owned by religious organizations and leased non-commercially to members, provided the membership requirements are not discriminatory. So I'm going to put these both in the same example, and guys, don't get offended, please. I'm putting private clubs and religious organizations into the same example, and that example is a gym membership. If I have 24-hour fitness and retro fitness, okay, can the people at 24-hour fitness come exercise at retro fitness? Let me know in the chat. Can they come exercise at retro fitness? Why not? Why not? No membership. So the discrimination here, that was key. The discrimination here, if you guys read it, members. There's no discrimination because you're not a member of this club. What is a religious organization? A club. So if I have my church and you guys are members of my church, for instance, right? And I buy a building, an apartment building, which was bought with the purpose of servicing members of the church, right? If you're not from this particular organization, I'm not saying from this religion, from this organization. There's a difference. There's different Christian or Catholic churches and mosques and whatever, right? There's different ones. But from this one, if you're not from the same one that I am, then you cannot rent from this building. You understand? These have to be leased non-commercially, meaning only to the members. Again, non-commercially, only to members. The moment it's advertised to the public, I put it on Craigslist, on Facebook, whatever, the moment it's advertised to the public, we lose the membership status. We can no longer discriminate. You guys got it? When you look at the question, look at membership. Is it a member of the group? If not, then you can discriminate. Okay, we can keep them out. Say no. All right. Jones versus Mayer. Notice that I have this in green. It's in green, therefore very important. So this is the second biggest movement of 1968. It wasn't only the fact that they added religion and national origin and the exemptions. Jones versus Mayer is the case that came to solidify the fact that 1866 was the base of all these protected classes and discrimination laws. So Jones versus Mayer is where Jones, an African American, sued Alfred H. Mayer Company because they refused to sell him a house in St. Louis County, Missouri, solely on the basis of race. So again, Supreme Court ruled in Jones versus Mayer that all discrimination in selling or renting residential property based on race is prohibited under the provisions of the 1866. Thus, while the Federal Fair Housing Act of 1968 exempts certain kinds of discrimination, look in green, very important, anyone who feels victimized by discrimination based on race may seek legal recourse under the 1866 law. So it doesn't matter these exemptions. If it's based on race, no exemptions apply. That's what we said right here with Jones versus Mayer. Okay? I can discriminate in an owner-occupied 1 to 4 family against everything but race. You understand? I can say, oh, you're from a different religion, I'm sorry. But I cannot say you're from a different race. I'm sorry, I cannot do that. If it's based on race, no exceptions apply. Remember this. Okay? All right. Now, in 1972, HUD instituted a requirement that brokers display a standard HUD poster. The poster affirms that the broker's compliance with fair housing laws in leasing, renting, advertising, and financing residential properties. Failure to display the poster may be construed as discrimination. What does that mean? I'll put it this way. I always like to give this example, and again, don't feel bad. Or don't laugh, actually. I always like to give this example. If you know anybody that's a law enforcer, right? So a police officer, for instance, having a badge that says I uphold the law and I'm here for that doesn't mean you don't discriminate, right? But having the badge is better than not having it at all, because now you need to uphold even more the law that you represent if you have a badge, right? So what they're saying is, if this equal opportunity housing poster is not at the office of the real estate office when they come investigate you for potential discrimination, not having the poster there is the first sign or the first step or the first checkbox that says this office potentially discriminates. All right? So again, it doesn't mean that you don't, and not having it doesn't mean that you do. But when they investigate you, it's the first step to show that you potentially do. So that's your first loss. Okay. So that's why if you guys ever come here to the office, you'll see that right at the entrance. If you don't see it on the way in, you'll see it on the way out. But right at the answer, I have both posters, the New Jersey and the federal poster, both of them, where it says we don't discriminate. Okay. All right. In 1988, notice I don't have 1988 highlighted because there's more 1988s. But in 1988, they added gender or sex as a protected class. They also had people with disabilities and families with children. And of course, there's exemptions to familial status or family status. So these are people that are with children under 18. There's exemptions. Now, these exemptions are very clear. And I think it's common sense. It's also based on membership. So this is not a membership that's disclosed membership, right? But they have to show, the only disclosure they have to give is that the housing is intended for older people. So it's not like, hey, you reached 65 or 62 or 55 plus, whatever. Congratulations, you're now a member of the seniors club. No, that's not it, right? So it's not a club, but the housing was built with that intention, like government designated retirement housing, okay? Or a retirement community, if all residents are 62 years of age or older. And these, by the way, 62 years of age or older are different than the 55 plus. See, in the 55 plus, only one member of the household must be 55 or older. So the second member could be 48, could be 40, could be 20, doesn't matter, okay? In the 62 or older, it's strictly for people aged at least 62. You guys got it? Thumbs up? Great. One thing I want you guys to write here is Oppa Gangnam Style? No, that was not it. Okay. It's OPA. It's Housing for Older Persons Act. This is an act that allows them to exclude minors because the housing was intended for older persons. Three. Oh, I'm getting there. You were already here? I was still on the... Right? Always ahead of time. Tina, what was the A for? Housing for Older Persons Act. Brandon, children are more expensive in this class. All right. So, number 4. Residential dwellings of 4 units or less, single family houses if sold or rented by owners who have no more than 3 houses. Remember those exclusions that we said based on the 1968 law? If it's owner occupied, 1 to 4 family, I can exclude people with children according to federal law. If I do not own more than 3 homes, single family homes, I can exclude people with children. That's what I said earlier. So that's one of the exemptions that we have under the 1968 law. But remember, this is federal. State might be a little tougher. Okay? All right, discrimination by the client. It's common sense. If you cannot discriminate, your client cannot discriminate. But if your client discriminates and you accepted them as a client, the agent, because you are a representative of the client, so you are the client, right, is equally liable for violations of the fair housing laws. So you are required to disclose to every seller that they cannot discriminate. And if they intend to discriminate, you cannot work with them. You should withdraw as soon as you know that there's discrimination. You should withdraw any relationship where discrimination occurs. You got it? Very, very important. Do not fall into this trap because the fines are hefty. Now, people who feel that they have been discriminated against under the Federal Fair Housing Act laws may file a complaint with the Office of Fair Housing and Equal Opportunity within HUD, or they may file a lawsuit with state court. If you're going to file a complaint with HUD, you have 1 year. Complaints with HUD, you have 1 year to file it. Okay? If you're filing a lawsuit, a federal lawsuit, you have 2 years. Look how everything is in green over here, right? You have 2 years to file a lawsuit. Next, penalties. You guys ready for this? Penalties. If discrimination is confirmed in court, the respondent may be enjoined to cease practicing his or her business. For example, a discriminating home builder may be restrained from selling available properties to buyers. Also, the plaintiff may be compensated for damages, including humiliation, suffering, and pain. In addition, the injured party may seek equitable relief, including forcing the guilty party to complete a denied action, such as selling or renting the property. And finally, the courts may impose civil penalties for first-time or repeat offenders. There's one thing missing here. Let me put it in big, bold letters. The court can impose punitive damages, punitive as punishment, with no dollar limit. Okay? So you have to pay for whatever damages you cause to the other party, and as punishment, the court says, well, $2 million, $10 million, whatever the judge feels like at that moment, based on your actions and how they woke up that morning, that's what you're going to get. There's no dollar limit. All right? Anybody intends to discriminate by now? If you intended, I'm sure after this you don't anymore. All right. Tina, that's up to the state. I'll address that once we get there. Section 8 is the state portion. But the answer is no for now. You cannot discriminate against Section 8. So you have to accept it. Unless you get yourself out of it right away. All right. Equal or Equal Credit Opportunity Act, obvious, is you can apply for credit. We already covered that in the previous chapter. You can apply for credit regardless of your race, color, religion, national origin, sex, marital status, age, and so more, right? This is the poster that must be at every office. Equal housing, right? And even says it's illegal to discriminate against any person because of race, color, religion, sex, handicap, familial status, or even national origin. Cannot discriminate. If this poster is not there, as I already told you, it could be deemed as potential discrimination. All right, next we have Americans with Disability Act. There might be, almost guaranteed to be, a question in the national portion of the exam. Okay? So remember, there's a national portion and there's a state portion in every exam across the United States. In the national portion of the exam, there's almost guaranteed to be a question regarding ADA. Right? ADA, Americans with Disability Act. What you need to remember about this, ADA, again, is for people with disability, right? It only prohibits discrimination against individuals with disability, but it's not everywhere. The discrimination is in public accommodations or commercial facilities. So what I want to say here is that ADA does not apply to residential. Does the landlord have to, in a residential property, does the landlord have to adjust the property to somebody in a wheelchair? The answer is no. In commercial properties, the answer is maybe. So the Act, and we'll go over more in detail in Chapter 24, as it says here, the Act requires landlords in certain circumstances to modify housing and facilities for disabled persons that can access them without hindrance. But again, not residential properties. Commercial properties, yes, in certain circumstances. That means got to make reasonable accommodations. Reasonable means it was easy to do it. Okay? Modifications to physical components of the building may be necessary to provide required access to tenants and their customers, such as widening doorways. Those are easy. They're reasonable, right? They're cheap. Okay? Changing door hardware, changing how the doors open, installing ramps, lowering wall-mounted telephones, keypads, supplying braille signage, right? And providing auditory signals. These are easy. Removing existing barriers, okay? If it's, again, readily achievable and is not cost prohibitive. So I don't have to restructure the whole building, right? And have massive expense of restructuring the building because of somebody with disabilities. So new constructions, obviously, they meet a higher standard, but old buildings, if it was easy, right? Like parking spaces. Parking spaces, it's easy to mark a parking space for handicap. Nobody can park there unless it's a handicap. That's easy, that's cheap. The braille signage in the elevator buttons, for instance, or auditory signals also for elevators. They're easy, they're cheap. I don't have to spend $20,000 restructuring the whole building and put an elevator, right? But if it does have an elevator, why don't I have these? That's what it is. So remember, write this down. ADA is for commercial properties and has to provide reasonably achievable accommodations. These are the three things. ADA is for commercial properties, right? Got it? So not for residential. Must provide easily achievable accommodations. People with disability, commercial properties, reasonable achievable accommodations. Remember that. So if you have a question in the state exam that says something like, or school exam, that says something like, the landlord in a two-family, must they, do they have to renovate the property? The answer is no. They don't have to do anything. But there might be an answer that says, instead of no, there might be an answer that says they can, right? They can renovate or they can adjust, but they can also relay that cost to the tenant. So if I have a residential property and somebody has a disability and they ask me, Bruno, could you please make these changes because my son or myself or my daughter or whatever, or a family member has the disability and they need accessibility? If I do it, I can do it and I can say, yes, no problem. It's going to cost X amount of dollars. So that the expense is on you, not on me, because I'm not obligated to do it. I'll do it, but I'm not obligated to do it. You guys understand? If it's commercial, it's a little different. Commercial, we have to do it. Again, if it's reasonably achievable. All right, the next thing that you guys fail a lot is residential property condition disclosures, environmental issue disclosures, warranty disclosures, inspection disclosures, and HOA disclosures. That's the other thing you guys fail a lot in the exam. Disclosures, 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 disclosures. I don't know how many times I can say disclosures. You have to present anything that affects the transaction. Doesn't matter who you represent. If it affects the transaction, so anything and everything that could affect the proposed transaction must be disclosed. So one of the ways to prevent disclosure issues, stuff that you did not say, one of the things to protect yourselves, you guys remember, It's the seller's property condition disclosure form. So the seller's disclosure form is very simple. Who, better than the seller, knows the property, right? Or who other than the seller knows the property better, right? Whatever way you want to ask is the same, right? Do I know the property? I'm the listing agent. Do I know the property? Other than the visual inspection that I did, that I'm required to do, right? I do not know. But I'm also required to ask questions. One of the ways to ask questions is, Mr. Seller, could you please, or Mrs. Seller, could you please fill out this form to the best of your knowledge? If you don't know how to fill out this form, please consult with your lawyer before you fill it out, for instance, right? We can help them out. I recommend you don't. Because then they can always say, oh, no, I just signed and the realtor filled it out. And then it's the same thing as nothing. All right? So have them sit down with their attorney, if anything. Right? You give them the form, have them fill it out with the attorney. Right? This disclosure is entered on state-approved forms. And again, it's the seller telling you the conditions of the property to the best of their knowledge. You are going to say what you feel about the property, and you have to give your opinion on the property. Okay? So again, a typical form requires the seller to affirm whether or not the problems exist in any of the listed features and so on. Once the seller has signed the form, they deliver it to the buyer, and the buyer must acknowledge the receipt and knowledge of the property condition disclosures along with other provisions set forth in the form. Our job, as I just said, so I'm going to go really fast in certain things because we covered this in agency, right? When we talk about agency. But very important, our job, if an agent is involved in the transaction, the agent must disclose any and all material facts that he or she knows, right? Or you should reasonably know about the property regardless of what the seller may have disclosed in the form. So if the seller says no mold, yet you're in the basement, as an example, and you see growing mold, right? It's growing by the second as you look at it, right? Then obviously you're going to disclose to the potential buyer that there's potential mold. So therefore, they should have an inspection, okay? Again, property condition and material facts. It repeats again. As explained on chapter on agency, an agent has the duty to inform. Look, it's in green, so it's very, very important. Guaranteed, there's questions around this. All right? It is your duty to inform the client of all material facts, reports, and rumors that might affect the client's interest in the property. Okay? So if I don't know the issues with the property and I'm putting an offer, right? Is that the true value? Is that the best offer I can give? It's not, right? It's not the best offer because I'm not fully aware of the conditions, all right? So a material fact is one that might affect the value or desirability of the property to a buyer if the buyer knew it. So material facts include the agent's opinion of property condition, adverse facts about the property condition, title defects, environmental hazards, and property defects. In recent years, the disclosure standard has been raised to require an agent to disclose items that a practicing agent should know, okay? Whether the agent actually knows or had the knowledge or not, and regardless of whether disclosure furthers or impedes the progress of the transaction. Your job is always to ask or develop the skill to identify certain things. So things that you should know, because you are the professional, okay? Facts that are not considered to be material and therefore should not be usually subject to required disclosure includes things like property stigmatization. So if there was a crime or death that occurred in the property, do we need to disclose these things? We don't need to. We don't even need to research if people died in the property or not, if there's a crime committed in the property or not, because that has nothing to do with the property value. An event or occurrence that affected the physical condition of the property must be disclosed, right? That, yes. Something that did not affect the structure does not have to be disclosed. All right, if you know about it, you might have to say it. So we're going to talk about this right here. You might have to say it. The presence of registered sex offenders in the neighborhood, according to Megan's law. We don't have to disclose that. We don't even have to research that. That's up to the families, right? And how concerned are they by this fact, right? To do the research, not us. Okay? We cannot. We're prohibited. In most states, state law prohibits us from researching these things. Okay? The agent may be held liable for failing to disclose, again, material fact, if a court rules that a typical agent in the area would detect and recognize the adverse condition. But there's no obligation, I have it in green, there's no obligation to obtain or disclose information that is immaterial to the transaction, such as property stigmas. Again, if the physical condition of the property is not affected, we don't have to disclose. Okay? Unless it's something that affects the transaction, like title issues, or the buyer doesn't have enough money, the mortgage was not approved. These things affect the transaction, so they must be disclosed. Okay? An agent who sees a red flag issue, such as potential structural or mechanical problems, should advise the seller to seek expert advice. Red flags can seriously impact the value of the property and or cost of remediation, in addition to the property condition per se. They may include such things as environmental concerns, property anomalies, neighborhood issues, poor construction, signs of flooding, poor floor plan, or adjacent property features. So properties are attached to yours. The following exhibit is part of a property condition disclosure form showing the level of detail that is expected in the seller's disclosure. So this is what we look for the seller to fill out. Okay? This is a as-is form, and every property should have this as-is form, meaning you, the buyer, are liable for researching more, not me. I'm giving you, as a seller, I'm giving you the best of me, of what I know, right? And it says here, you have to do this to the best of your knowledge, otherwise you could be liable. So we're going to put property address, seller's name, property age, date seller acquired the property, do you occupy the property? If not owner-occupied, how long has it been since you occupy the property, and so on. It's going to ask what it has included in the property. What do we have there, right? But this is not the most important part. This is roof, what type? What's the age, approximately, okay? Other items. To the best of your knowledge, is the seller aware of any defects or malfunction? And here's the potential defects. Are there any defects in the interior walls? Yes, no, or I have no idea, right? Ceilings, yes, no, I have no idea, unknown, right? And so on. So the condition of everything. If there's something that you say yes to, then you have to explain, Mr. Seller or Mrs. Seller, and so on. Okay? And then, of course, all the way at the end, like a bunch of questions to the seller, all the way at the end, they certify that what they answered is true to the best of their knowledge and the penalty of perjury. So if something is not true, you can go after the seller because they made a statement, right? And then the buyer signs saying, yeah, I received it. Okay? Any buyers here? Did you ever buy a house? Raise your hand if you bought a house. All right, cool. Those of you that bought the house, did you receive this certification from the seller? Raise your hand. Nobody? Are you kidding me? Those listing agents are awesome. Cool. This industry is doing great. So this means, guys, that you cannot sue the seller almost, right? It's going to be very difficult for you to sue the seller if you don't have property condition disclosure statement. The seller, without signing this, is pretty much saying, hey, I don't know. That's it. I don't know. Maybe there was issues, maybe there wasn't. And then all the liability falls on the listing agent and the buying agent. Because the seller did not know, or at least did not disclose. When it comes to the he said, she said type of thing, or hearsay, as it's called in court, right? Very difficult for you to point the fingers. So make sure you guys understand this. If you get a listing, ask for the seller's property condition statement. If you have a buyer, ask the other realtor for the seller's property condition statement. Always protect your clients, okay? Tina says, I don't know, too much paperwork to remember. I'm sure. But go check it. Because if there's issues with a property, you might be able to go after or not. Very important. All right, environmental issues. What do we have? Environmental issues. We have lead-based paint. So we must disclose, right? We talked about environmental issues before. We must disclose to a potential buyer if the property was built before 1978. Sorry. If the property was built before 1978, this is a federal law, and every state has a reference to this law. So it became both federal and state law. If the property was built before 1978, we must disclose the potential presence of lead-based paint in the house, even if the house was renovated. Okay? Because it was built before 1978, we must provide that disclosure. Oh, but I gutted everything, complete reno. I don't care. Built originally before 1978. Unless you took the whole foundation out and you built brand new everything, right? It was still built before 1978. So the disclosure must be given. And the disclosure is protect your family from lead in your home. That's a pamphlet that must be disclosed. And it must be part of the contract as well. A checkbox in the contract that says home built before 1978, know your rights. That's pretty much what it is. All right? Mold. If there's mold, we must disclose presence of mold. I just said that before. Asbestos. I'm going very quick at this, okay? Because we already covered these in a different chapter. Asbestos. They're harmless in their original condition, but when you disturb them, when you do in renovations, they can break down into tiny filaments and go into your airways and potentially cause lung cancer. So if there's asbestos or potential asbestos in the building, it can only be removed, and it has to be removed by by professionals, or encapsulated or contained by professionals, not you. Okay, so certified professionals. Air quality. One of the things that we test for always is radon, especially in the northeast of the country where there's high levels of radon, the northeast of the country. Okay, so every state in the northeast suffers from a lot or high levels of radon. Water quality. Under the water quality, mainly if your property has, and we also talked about this before, if your property has a well, for instance, a private well, or on-site or off-site, so if it's not provided by the municipality, right? If it's a private well on-site or off-site, then we must test for contamination in the water, okay? Carbon monoxide. Like radon, it's an odorless, colorless, toxic gas. So if we know that there's potential carbon monoxide, that's why we have to have the carbon monoxide detectors there, right? If we know about it, potential issues with a combustion, right? Then we also must disclose if we know about it. So make sure you test always, or see that there is, not test, make sure there is one carbon monoxide installed, or a fire extinguisher installed as well, right? Those have to be there, along with smoke detectors must be installed. And every state has their rules regarding how many must be in each unit. Septic systems. In an area that has septic systems versus, again, the sewer system provided by the municipality, in an area that has a septic system, if you know, first of all, if you're a realtor in that area where it's predominant septic systems, septic tanks, then you should know that these have to be tested. Okay? It's part of the inspection. If you know that there's a faulty septic system, you must also disclose. Okay? I mean, I think these are common sense. Radon, I just explained that as well. Urea formaldehyde is a type of insulation. Underground storage tanks, guys. This is oil tanks mainly. For residential properties, oil tanks for heating. So if there is a presence of an oil tank, then you must either remove the oil tank or you need to contain or mediate the oil tank. So take all the oil out, fill it with sand at least, right? The advice is always to remove. But if we are not sure because it's old enough, like too old, I'm sorry, there's a chance that there's a crack in it already. And by removing, it could contaminate the soil and even travel to adjacent properties, making you liable for everything, if you guys remember from CERCLA. Okay? I talked about drinking water must be tested as well. Again, if there's any septic system on the property or a private well or anything like that. Brownfields, every time you see brownfields, this is for commercial or industrial sites that might contain toxic material. That's why, does anybody remember ISRA? We talk about Industrial Site Recovery Act, ISRA. Okay, so if it's a commercial industrial site, at the transfer of ownership or occupancy, it must be tested to make sure that there's no contamination to the property. All right, so we did talk about that. EPA, Environmental Protection Agency, and so on. This is just repeated. I'm going a little fast because some of the stuff is repeated, like this one. You have to provide a pamphlet if the property was built before 1978, and if we're talking about lead-based paint. So must provide the pamphlet. Okay, and also includes a line in the contract that says property built before 1978. One thing you must remember. One thing you must remember is the seller is not required to test for lead-based paint, okay? But must allow the buyer 10-day periods to inspect the property for lead-based. Tina says she got kicked out. Trying to get back in. Okay. We're here. We're not going to be here for too long, but we're here. We'll wait for you. Or not. I don't know. We'll figure it out. All right, next. So 10-day. So that means that usually after the third business day becomes, let's say in the state of New Jersey, after the third business day becomes final contract. That's a cooling off period. Becomes a final contract. And we could literally say, hey, you only have 5 days to inspect the property. What we usually do is give at least 14 days. That's what we usually do, at least in our agency. That's what we do. Why do we do 14 days? Just because we don't want to have to figure out, one of the reasons, we don't want to have to figure out if it's a property that meets the lead-based paint requirements or not. So we just make it standard across the board. A lot easier. Okay? All right, CERCLA. Things you need to remember about CERCLA. CERCLA is a comprehensive environmental response compensation and liability act. Talked about this in a different chapter. But they created the Super Fund, which was a $9 billion fund, right? And in 1986, SARA came along, Superfund Amendment and Reauthorization Act of 1986, right? So these, you need to remember that they pretty much made current landowners, as well as previous owners of a property, liable for environmental violations, even if they are innocent of a violation. So unless you can prove that you were 100% innocent, meaning, hey, I was literally unaware, we did an inspection, it happened before me, right? It was my neighbor. Like, if you can point the fingers and say you had nothing to do with this, you might be able to walk away without having to pay for the cleanup. And this fund, which is now a $45 billion fund, this fund will clean up and then go after what's called the potential responsible parties, or PRPs. Okay? But until then, you are liable for it. Okay? So sellers often carry the greatest exposure, And of course, real estate licensees may be held liable for improper disclosures. Okay? So again, in sum, for your own protection, licensees, for your own protection, we must be aware of potential hazards. We must disclose known material facts. We must distribute the HUD booklet and know where to seek professional help, right? And this is not psychological help, okay? Professional help, we're talking about the home inspectors, right? That will inspect the property for potential damages. All right, Tina is back. Tina, we're done. Thank you for joining us. Just kidding, we're still going. Purpose and scope, home warranties, and all this stuff. We'll talk about that when we get to the states. Limitations, inspections. Guys, we talked about this already, so I'm going to skip. Okay. You should read this. It's not like when you present this to when you have a client, but you should already know this and explain to your clients why you need a home inspection. Okay. For instance, definitely read it. It's everything just we just went over. Okay. Again, we're just repeating a bunch of stuff. Agent disclosure duties. Most states require disclosure of known material facts regarding residential properties for 1 to 4 units. If you know about it, say something. So if you know something, say something. Simple. Okay? I think if you guys understood what I said until now, the reason why I went a little fast, I covered what was most important. Things that affect the property or the transaction itself, okay, must be disclosed. This is another one. HOAs. Homeowners Association is the reason why condos are easy to buy, very difficult to sell. Because if the HOA does not cooperate in presenting declarations, articles of organization, bylaws, articles of incorporation, organization, operating agreements, rules and regulations, party wall agreements, minutes, which are for the meetings of annual owners, right? Minutes of the directors, and very important, this is one of the most important, the financial documents about the HOA. This is the one where they usually fail, okay? Also, the fact that they might not have lists of insurance policies or assessments by unit type. These right here, these final 3, are the main reasons why there's so much difficulty in selling an HOA. Okay, for the buyer, it's easy. Once we get everything, it's approved. For the seller, if they don't provide in time, the buyer might no longer be approved or have to move to a different property. So this is the reason why HOAs usually damage the deal. All right? Now here comes the question. Why would we need to provide financial documents of the HOA? I'm buying 1 unit within the condo association, right? Why do I need to have financial documents? Let me know in the chat real quick. What do you guys think? Why does the HOA or homeowner association have to provide financial documents about what the association is doing or not doing? Anybody? YouTubers, we got 3. You guys are watching. Why do we have to provide? What do you guys think of? Why do we have to provide financial documents of the HOA, of the homeowners association, to a potential buyer? How would that change the purchase? How does that affect, how is that a material fact? How does that affect the transaction? Any ideas? I like your answer. Hold on. Motivates it. So we have HOA fees It motivates. Okay. To see where the money is going to. Okay. To know a lot of details about property value. Okay, so property value is not so much of the HOA. That's individual value within the HOA. So not so much the HOA. But it is about money. The trust, not so much. But look right here. Liens. Right, absolutely. To see where the money goes to, liens. So that means unpaid bills of the HOA. Okay. Shanice, you're too late. I'm sorry. I'm moving on. So the question was, why in an HOA, so if you're buying a condo, why does the HOA have to provide the financial documents of the HOA? Not of the unit, but of the HOA. HOA is the Homeowners Association and pretty much has to do with the common elements. Look, if there's liens against the common elements, you're going to be part of this, right? So your property will be affected and might have to pay for it. If there's liens, things are unpaid for, it could raise the HOA fees. But it's also to disclose the actual HOA fees and where they're going to. See, for potential financing, the mortgage company wants to look at the actual fees and see if you're approved for $2,000 a month and the HOA fees on top of the mortgage brings you up to $2,100 a month, then you're no longer qualified to buy that particular property. You understand? So you're approved for $300,000, but if once you put the HOA fees there, it brings your approval down to $250,000, as an example. So can you buy this $270,000 condo? Probably not. You understand? So all these fees must be disclosed. Also this one, insurance. If there's no insurance in the common areas and somebody slips and falls, guess who's responsible to pay for that slip and fall? All the homeowners. And that could be potentially a lien against your unit. You guys understand? That's why these are very important. Assessments is tax assessments against the unit, okay, by unit type. Okay? But all this must be disclosed. Very, very, very important. All right, other professional practices, and that's how we're going to close this chapter. Code of ethics. And ethics is pretty much like your moral compass, right? What you should do and what you should not do. Moral compass, right? The good things that should be done, the bad things that shouldn't be done. Okay? Job performance, what is expected of you, your duties to the clients, duties to the customers, disclosure again, and professional relationships. So we had all of this right here in agency in chapter 11. Very, very important you guys remember this stuff, okay? If it's repeating, it's because it is important. Now, the real estate industry has developed a code of professional standards and ethics as a guideline in serving real estate needs of consumers. This professional code has emerged from three primary sources: the federal and state legislation, the state real estate licensing regulation, and the industry self-regulation through trade associations and institutes, like, for instance, the National Association of Realtors. Okay? Federal legislation focuses primarily on anti-discrimination laws and fair trade practices. We already covered those, right? State laws and licensing regulations focus on agency and disclosure requirements and regulating certain brokerage practices within the state jurisdiction. Real estate trade groups focus on the professional standards of conduct in every facet of the business between professionals and with the consumer. Okay? By observing professional ethics and standards, licensees will serve clients and customers better, foster a professional image in the community, and avoid regulatory sanctions and lawsuits. Today's professional ethics are not only important to one's career, but they're also legal imperatives. Now, the National Association of Realtors created their own back in 1913. You guys can click here. This was updated. Well, don't click on the screen. But if you guys download this, booklet in this page in the chapter in the student portal, you can click on it directly and it takes you to the code of ethics, the updated code of ethics. All right, or you can Google NAR Code of Ethics, and they'll give you the most up-to-date. Actually, they just updated this year as well. The standard of most codes for real estate licensees concern the following general practices, which is the job performance, right? And a professional real estate agent must understand the skills and knowledge the profession requires and make a commitment to maintain and improve expertise in the areas, right? We talked about this in the very first day, to develop your skills, the knowledge, right? So it's your job to have market knowledge, to understand real estate laws and the evolving standards of practice. Just 1 second. It wouldn't be a class without some sirens going through. At least if you're in the club, you know why the sirens are coming through. Like a hot song is going on, right? I hear. Anyway. All right. Other aspects of professional performance that are usually supported includes promoting exclusive listings, promoting the professionalism of the real estate industry, promoting arbitration of disagreements rather than litigation. So let's try first to figure out a mediator between us instead of going to court. So that's the first thing, right? Obtaining transactional agreements between the parties in writing, submitting offers and counter offers in a timely, objective manner, keeping the funds of others. So everything we covered, guys, these are things that we must keep in mind and was established through an agreement, a national agreement, and then every state enforces a little bit more agreement. So providing equal professional services to all persons, we just covered that. Services only within agent's area of competence. So if you don't know about it, don't try to sound like you do. Get somebody that's a professional in that particular area, right? Observing the highest standards of truthfulness in advertising and cooperating real estate boards and commissions in their enforcement of standards. A real estate professional must recognize the limits of the agent's role and avoid practicing other professions beyond the agent's qualifications, such as law, if you're not a lawyer, investment counseling, if you never invested. So, Mr. Badur, you asked this question before, investment analysis, right? If you don't do it, if you don't know about it, bring somebody that does. Don't try to say something that you do not know. Securities brokerage or even tax advising if you're not a CPA. Okay, if you're a tax preparer, you have some knowledge about it, great. But even then, careful. Okay? And never try to wear both hats at the same time. There's nothing wrong with, hey, I helped you sell your house. By the way, I prepare taxes. There's nothing wrong with that after the transaction. You got it? Oh, by the way, I'm an electrician. If you ever need help to fix that problem we went through, right, during the final walkthrough, I can help you. Mention this after. Don't try to do two things at the same time in the same transaction. Okay? At least that's my best advice for you. Even if you are the professional, there's nothing wrong with suggesting your services after. Don't mix things, because then you can lose one license and potentially another license. You'll get sued for both at the same time. Right? Now, most code of ethics uphold the commitment to fulfill fiduciary duties. Right? And these applications include honestly representing market value and property condition, respecting rights and duties of other client-agent relationships, submitting all offers in a timely fashion, right? Avoiding commingling and conversion. Guys, what is commingling? Commingling. Commingling, a Chinese word. What is commingling? No offense to the potential Chinese watching this on YouTube. Commingling, you guys got to know this. Oh, nope. Yep. Mixing your money with clients' money. Using money that's not yours. Combining funds. Mixing funds. Yep. So I think that's where you're going, Mr. Badur, with joining. Okay. Make sure you add the rest. Don't just say joining. Joining funds with other people's funds with your funds. Okay? Not just joining money, because I'll join money every day. I'll join it to my bank account, right? It was once here, and now it's going to be joined into my bank account when I deposit. Money that's not yours, not your money, exactly. So we have commingling, and then within this commingling, there's something called conversion. So one of them is, Brandon? QWW plus minus. I don't know what you're saying here. I knew it was not you. I'm just messing with you. You don't have to yell at me. I already told Lula not to put caps. I hate when people yell at me. All right. Okay. Thank you. All right. So commingling is mixing funds of other people with yours. Conversion is using those funds that are not yours. Okay? Conversion is using those funds that are not yours. Thank you, Diana. I appreciate you moving the camera. All right. Next. These people. Duties to customers. You can tell him that he's fired, by the way. That's it. All right. Duties to customers. First of all, and if you guys don't know this by now, you're all fired. Okay? Duties to customers. What is the difference between a customer and a client? Let me know in the chat real quick. What is the difference between a customer and a client? Very important for state exam. I can guarantee you, state and school exam, I can guarantee you, there's so many scenarios and so many questions around customers or clients. Who do you owe duties to or not? And what types of duties do you owe to either one of them? Let me know in the chat. What's the difference between customers or clients? This is where you guys fail the most. Guaranteed. Every time I see a score report from the state exam that where you might have missed by a few points or whatever, right? Every time I see one, it's always guaranteed. And I see even when you pass, I get all those results after. I guarantee you, where you fail is agency. Agency is understanding who's a customer, who's a client. All right? So the client hired you. Great. The client hired you. That's a client. What about a customer? So client employer, yes, the one who wants the service. Well, all of them want the service, right? But client equals employer, hired you. Client is usually the seller, could be the buyer, okay? But in this case, let's assume the seller, then the buyer could be the customer if there's no contract, yes. But you could represent the buyer as well, then the buyer is a client. If you don't represent, so Lula, let's go back to this. You represent the buyer, I represent the seller, right? And I did this with you also in agency, right? I represent the seller, you represent the buyer. Your client is my customer. My client is your customer. Why? Because I don't represent your client and you don't represent mine. You understand? So the difference is who, okay? The difference is who represents, if there's representation or not. So client hired you, so they employed your services. Customer did not hire you, you're just being fair and honest with them. So let's use Denise's example here. Customer purchases products or service from a company, okay. But you are the rep for the company. If you are the rep for the company, then you're the rep for the seller. They hired you to sell those products to customers. So you must uphold your client's best interest. That's the difference between clients and customers. Customers are third parties who you do not represent. Okay, so in the example that I gave with Lula, right, she represents the buyer, I represent the seller. The client for me is a seller, and the buyer is a customer. I do not represent. The client for Lula is the buyer, and the seller is a customer because she does not represent. Okay? But there's duties. You're lost, Tina? Well, you are on Zoom, and this session is session number... okay. Difference is this. Giving me a lot of work here. It's Monday. Come on, relax. So the difference is this. We have a seller. We have a buyer. Okay. Again, this is where most mistakes happen in the state exam. Okay, because there's roughly 22 questions just on agency alone. Out of 110, there's 22 questions on agency alone. That's 20% right there. Yep. Okay. So there's a seller. There's a buyer. I said I represent the seller. Okay. So seller hired Bruno. Bruno, me, becomes an agent. Right? Now, if I'm the broker, I'm the direct agent. If I'm not the broker, I'm a sub-agent of the client, right? Because I represent the brokerage represents the client. So if they hired me in this capacity, they are the client of the agent. In this capacity, they are the client of the agency. There's a clear separation here. I represent the client because they hired me. Do I represent the buyer? No, because the buyer hired Lula. So Lula is the agent for her client. Okay, there's a clear separation. If I represented both of them, then both of them would be my clients. If I got hired by the buyer and I got hired by the seller, both of them would be my clients. This separation here, or this wall, right, makes this person a customer. A customer to me. I don't represent them, but I still have to treat them fairly and honestly, and vice versa. I still have to treat them fairly and honestly. I don't represent them. So if I work for a restaurant, who hired me? The restaurant. Okay? When people walk in and sit down to eat, they are customers. If a customer says, Bruno, I really like the food, yeah, the Quiznos example. Right? If I really like the food, but I don't want to pay. Who do I represent? The customer or the client, the employer? As a waiter, I represent the employer, right? Which is the restaurant. So I cannot give the food to you. I would have to consult with my employer to see if they're okay for me giving you the food. I cannot just go and say, yes, I'll smile at you. I'll be nice to you. I'll be fair to you. I'll be honest with you. But I don't have to do what you want. Okay? I'll treat you nicely, but I don't have to do what you want. But I have to do whatever my client wants. You guys understand the difference here? Client hired you, therefore you uphold their best interests. Client hired you, Lula, therefore you uphold their best interest. I have to treat your client fairly and honestly. You have to treat my client fairly and honestly. All right, with that being said, you're welcome, Tina. With that being said, if you're dealing with customers, you have to honestly represent market value and property condition. So I cannot hide from you, right? So Lula, I cannot hide from your buyer that there's a bunch of damage with the property. If I know about it, even though your client is not my client, I still have to disclose the property condition. I have to avoid calling a service free if in fact it's contingent upon receiving some type of commission, right? I love when people say, oh, I'll represent you, buyer, or I'll work with you, buyer, and it's for free. Not free. It's not free. You're going to get paid, maybe not from the buyer. Usually you get paid from the seller, but it's not free. What you can say is, you don't have to pay me because the seller usually carries the cost. That you can say, but you cannot say it's for free if in fact you're getting paid to do the job. You understand? That's a misrepresentation in itself. So there is financial interest, and the buyer is entitled to know, right? Whether it's a customer or client, they're entitled to know that you will get paid in the transaction. There's some type of conflict of interest. Why do they have to know that? Because sometimes we're looking at the highest commission versus what serves my client the best. So they're entitled to know, oh, that's why we went for this house instead of the one I really wanted. There. You understand? So a lot of agents, that's how they act. Commission, even though they don't get paid by the buyer, but commission versus client or customer. Okay? Advertising truthfully, we have to, regardless of who you represent. Okay. In compliance with applicable laws and to promote respect for the real estate profession, a licensee should be careful to disclose that the agent, again, is receiving compensation from more than one party in a transaction. Property defects are reasonably apparent. However, there's no duty to disclose a defect that would require technical expertise to discover. So if they find something later on that's impossible for you to see, you could not have known about it, right? You are not the professional to inspect the property. That's why we ask for home inspections. Any interest that the agent has in the listed property if the agent is representing a party concerning the property, right? Any profits made on the client's money, the agent's identity and advertisements, the agent's representation of both parties in the transaction. So if you represent both, the buyer needs to know that the seller is your client, the seller needs to know that the buyer is your client. You're representing those, both parties. So that's a disclosed dual agent. You represent both parties. The clients have to know. Why? Because you're getting full commission. That's one thing. Second thing, whose interest do you represent? More one or more the other? Neither. Okay? You have to be impartial when it comes to representing both parties, right? The identity of the broker and firm in advertising as required by state law. Why? Because they need to know who to sue in case you take advantage of them or you don't disclose something. They need to sue you and your broker. And of course, the existence of accepted offers and so on. Can the seller previously provide a document for the buyer to sign that abolishes them from any liability since the property was inspected at closing? A little lost on this. You're talking about you wrote Circle and Superfund. So if there's a spill later on, that's what you're saying. If there's a spill later on, are they exempt from it? Is that what you're asking? Okay. So the way it works with Circle is a little different than just simple disclosures. The buyer is not always required to inspect the property for spills, because if the property shows that it's natural gas, for instance, then there's a high possibility of not having a underground storage tank. Okay. Sorry, we're very active today in Newark, apparently. Where was I? So it's not a requirement. Should you advise your client, hey, it's only $150 or $200 more, you should have a potential site assessment for potential underground or tank sweep for potential underground storage tank? Should we? Yes. Do they have to? No. So as a realtor, you did your part. Does that release the seller's liability of not disclosing that there was one and potential leaks or damages to the property? No. So you can sign something saying as is, right, of the things that I'm aware of. But it doesn't release the liability here of the things that were impossible for me to be aware of. You understand? So can you release liability Yes, if you disclosed fully. That's why the seller's property condition disclosure statement. If you disclose fully, to the best of your knowledge, that these are the conditions of the property. Other than that, no. So if we can prove that the potential responsible party for this was a seller, then the seller is liable. And I'll give you this example. Again, I think I mentioned I have a family member that bought a property, and the day that he bought the property, there was a sewage backup. So as soon as he turned on the water, huge mess in the house. You tell me that happened between the final walkthrough and the and the closing. I was like, that was overnight, right? $30,000 later, gets fixed. You think that was a problem that happened from one day to the other? Or that the person that bought it was able to damage the sewer so much in one day? No. So that doesn't release liability from the seller. They knew about it. Now, the home inspector might be liable as well because apparently they did a really bad job. You understand? So we can sue everybody up the chain. It doesn't release liability at all. Because a home inspector is partly liable for not doing the property inspection or suggesting the property inspection, right? And the seller is responsible because it's obvious this did not happen overnight. It's obviously that it's not the first time that there was sewage backup, right? And look, I don't know about you guys, but I don't think anybody goes around and starts opening the water and flushing as they're walking through the house to potentially buy, right? You don't go there, ooh, what a nice toilet. Flush. Right? Let me see if the shower, like most people don't do this. I don't think anybody does. Right? So again, I'm not talking about the circle. I'm just putting this as general, right? The seller, even if the buyer signs that property condition statement, the seller might still be liable. Because it does say there, if any of these statements are untrue, then you are liable for it. Okay? Right there. The intention of the seller's property condition disclosure statement is to release liability. But if you already knew about it, there's nothing you can do. Right? So you disclosed everything. You knew the issues. You disclosed everything. You're free. Then it's on the buyer that should have done the certain inspections and repairs. Okay? I did. Of course. What did I tell you about Portuguese people? Tough. I'll kick you out of my house. What are you doing? Want to use the toilet too? No, get out. House looks great. That's it. You have the right to inspection later on. That's it. Here, testing my toilets. Seriously. Anyway. But I agree with you guys. Yeah, low water pressure is misery. Yeah. Ruth is laughing. Anyway. All right, so where were we? Professional conduct excludes disparagement of competitors. Real estate professionals also forgo pursuit of unfair advantage. Arbitrate rather than litigate disputes. Respect agency relationships of others. This, oh, by the way, this happens a lot. This happens a lot where you know that somebody's representing the buyer. The buyer walks in, right? That's why our open house sign-in sheets always ask if you're working with a realtor, what's the name, right? Because we don't want to steal the buyers. I mean, it's great to have the full commission, but at the cost of somebody else's loss? I think that's fair? It's not. But a lot of realtors do this. Very sneaky. Okay? Conform to accepted standards of co-brokerage practices and so on. Guys, here's some links that I highly recommend that you guys go through. I'm not saying prior to the exam, but at least after the exam, once you go get licensed and once you start working, keep these in mind. Save these somewhere as links for you to review for several reasons, especially this one right here. Advertising guidelines. Know what you can and cannot say in advertising. Okay? Especially this one. A lot of things you cannot say in advertising. All right, guys. Do you guys have any questions? Those of you revisiting this chapter, I hope it helped clarify a few things. Those of you that did it for the first time, do you have any questions you'd like me to address? Let me know now. I mean, after 3 weeks, I think it starts becoming, you guys start becoming a little bit more comfortable with the terms and the information, right? It's the first day, it's tough, but this was on the first day, it was tough. Come on, you Portuguese, you can remember this stuff. Gabriella, refresher was great. You're welcome. Mr. Rodor, are completing closings in one session? Yes, closings, chapter 21 is by itself. Questions, guys. Take advantage. YouTubers, questions. Take advantage now. Or forever, hold your peace. All right, I'm gonna check my Facebook and Instagram. I'll give you guys time to figure out questions. Oh. All right, I'm just messing with you guys. So if there's no questions, guys, you know I'm always available, so you can ask questions in the group chat or directly to me. If you have no questions, then I'll see you guys tomorrow if you're going to be in the morning class. If not, I'll see you in the evening class at 5:30. All right, guys, have a great evening. Thank you, Lula. I appreciate that. Have a great evening. I'll see you guys.